Welcome to this explainer. I am absolutely thrilled to have you here today because we're jumping straight into a topic that's quietly causing a bit of panic in boardrooms across Europe and the UK. We're looking at a fantastic July 2026 article by AJ Thompson from North Door, and it completely shatters some very comfortable corporate illusions about European data storage. For a long time, compliance teams felt totally secure just picking a cloud region in Europe. Box checked, right? But as we're about to see, the geopolitical and regulatory landscape has fundamentally shifted. And that old comfort zone? It's pretty much gone.
Okay, let's dive into this, because this exact paradox is what IT teams are really struggling to answer. Think about it for a second. Your servers are physically humming away in a data center in Frankfurt, Germany, or maybe Dublin, Ireland. But the company that actually owns those servers, your cloud provider, is headquartered over in Seattle, Washington. When a legal conflict pops up, which rules apply? Is it the laws of the land where the server sits, or the laws of the land where the company is incorporated? It's a massive question, and the answer completely changes your organization's risk profile.
To understand why this is such a huge issue, we really have to clear up a critical foundational misunderstanding. People constantly mix up data residency and data sovereignty. Residency, that's just a geographical fact. It merely tells you where the server is physically bolted to the floor. Sovereignty, however, is a legal reality. It dictates which jurisdiction's laws actually govern that data and, more importantly, who has the authority to compel access to it. So write this down: residency absolutely does not equal sovereignty.
That crucial distinction brings us to our very first myth bust of the day, the data residency trap.
The reason that residency myth totally falls apart comes down to one massive piece of legislation, the U.S. Cloud Act of 2018. You can kind of think of this as a modern legal Trojan horse. Under this act, if your cloud provider holds U.S. incorporation, if they're a U.S. domiciled tech company, U.S. authorities can compel them to produce data. And here is the kicker. It doesn't matter where in the world that data is physically stored. If they're a U.S. company, they are subject to U.S. law, completely overriding whatever local data center contracts you might think are protecting you.
Now, what's really interesting about this is the sheer extraterritorial reach of this text. The law explicitly states they can compel data production anywhere in the world. So the physical location of your Frankfurt data center is legally irrelevant to the US government. So many companies assume that they're 100% GDPR compliant, they have this magic shield against it. But they don't. An organization can be totally GDPR compliant and simultaneously hold data that is legally accessible to US federal agencies under a valid Cloud Act order. They're just two entirely separate legal frameworks. Let's look at how this legal tug-of-war has actually played out over time. In 2018, we got both GDPR and the Cloud Act, basically parallel frameworks pulling in totally opposite directions. Then, fast forward to 2020, the European Court of Justice steps in with the Schrems II ruling, invalidating the old Privacy Shield agreement precisely because U.S. surveillance law created risks that EU law couldn't counteract. We hit 2023, and we get the new EU-US data privacy framework. But guess what? Legal challenges are already underway. The long-term durability of these agreements is never guaranteed, which is exactly why relying on them instead of genuine sovereignty is such a massive gamble.
And that transitions us perfectly into myth 2, the encryption key catch.
Here is a rule every single board member needs to memorize right now. Encryption is absolutely essential for stopping unauthorized third parties, like hackers, from accessing your data in transit or at rest. But encryption does not alter the legal status of the data. A Cloud Act order served on a U.S. cloud provider doesn't initially require them to hand over perfectly readable text. It just requires them to provide access. And that access depends entirely on one big thing: who holds the keys.
Let's break down key custody real quick. With provider-managed keys, if your cloud provider holds the encryption keys, or if the key management operates inside their infrastructure, well, your data is legally accessible to them. And by extension, it's accessible to a government subpoena. Feeling legally secure in that setup is really just security theater. To have actual, genuine sovereignty, you need a bring-your-own-key model. The customer must hold sole custody of those keys, managed entirely outside the provider's environment. This is especially vital now under the 2024 EU Data Act, which establishes some incredibly strict rights around data access and contractual clarity.
All right, let's move to our third and final myth: the regulatory reality. Over 4 billion euros. Let that sink in. That is the staggering total of GDPR fines handed out since 2018.
This number is a massive wake-up call because regulators are no longer just going after the tech giants. Regulatory reality does not scale by company size. If you have even one single customer in the EU, GDPR applies to you. And as enforcement gets more mature, regulators are actively targeting organizations of all shapes and sizes. No one is flying under the radar. But hey, it's not just direct regulatory fines you have to sweat anymore. Take a look at the EU's sweeping NIS2 cybersecurity directive, which member states had to transpose into law by October 2024. This directive pushes cybersecurity obligations way, way further down the supply chain. If you provide services to an EU market, or even if you just sit in the supply chain of a regulated entity, you have indirect exposure. Plus, commercially speaking, data sovereignty has gone from being a tiny single line in a procurement RFP to a major deal-breaking requirement. If you rely on false assumptions, you aren't just risking a fine. You are literally losing real business to competitors who can prove genuine sovereignty. So, the crucial point is, how do we actually fix this exposure? Let's talk about achieving true data sovereignty.
To meet the standard that enterprise buyers and regulators are demanding today, you need absolute clarity on these 4 pillars. First, where does your data physically reside? And yes, that includes backups and data in transit. Second, which laws govern it, factoring in the extraterritorial reach of the provider's home country. Third, who actually has the legal authority to compel access to it? And fourth, data mobility. Can you move your data quickly if a legal challenge forces you to? The most practical answer for sensitive workloads is increasingly a hybrid architecture. That means using a provider that sits entirely and strictly within UK or EU legal jurisdiction, rendering them totally immune to US extraterritorial law. And this brilliantly illustrates exactly what you need to do next. Before you sign that next cloud contract renewal, you've got to take these 3 immediate, actionable steps. Step 1, audit your keys. Are you truly using a bring-your-own-key model? Step 2, map the legal jurisdiction of the parent company, not just where they built the data center. Document whether the Cloud Act applies to them. And step 3, review the fine print. Under GDPR Article 28, your contract has to explicitly state what the provider will do and exactly what they will tell you if they ever receive a government request for your data.
I want to leave you with a provocative thought today. Right now, this very second, can you confidently answer who holds the actual encryption keys to your organization's most sensitive data? Think about it. Because if the answer is your US headquartered cloud provider, your data sovereignty might just be a total illusion. It is time to check those contracts, audit those keys, and take back true control of your data. Thanks so much for joining me on this explainer. Keep learning, and I'll catch you next time.